All right, I think we're going to get started with today's presentation. Welcome everyone to today's webinar on how to handle post-pandemic harassment and discrimination complaints. My name is Carl Nazanek, and I am joined with me by my colleague, Todd Horn. We are attorneys with Venables labor and employment practice, and we regularly help our nonprofit clients handle a variety of employee-related issues and employment litigation. Between Todd and I, we have over 40 years of experience, both investigating and litigating claims involving harassment, discrimination, and other types of employee-related claims. And in fact, Todd has actually written a book on employment law that addresses a lot of these issues that courts regularly cite as a leading authority. Our presentation today is designed to give you some practical guidance on responding to and investigating claims and complaints of harassment or discrimination by both employees as well as third parties. Todd and I have been fielding a lot of questions regarding these issues in recent months, as more and more employees are coming into the office following long periods of remote work during the pandemic, as there's more and more interaction, frequent interaction, in-person interaction, and oftentimes we see informal interaction between employees and other parties in the workplace. So we think that this webinar will be helpful for organizations that are planning on reopening or that are already starting to see more employees come into the workplace, or really for anybody who just needs a refresher on the laws that govern and the processes for handling harassment and discrimination type issues. So our agenda for today is to cover best practices throughout the entire investigation process, from the very first steps for how to respond to a complaint, through the interview phase, the document review phase, all the way to the very end, to the determination, and then taking appropriate remedial action. We're going to be covering issues that implicate both employee issues and complaints, as well as third-party issues and complaints. And we'll be addressing not only best practices, but also some common pitfalls and some common mistakes that we see nonprofit organizations make as they handle these types of issues. And finally, we have reserved some time at the end to cover any questions that you may have. So feel free to submit your questions through the Q&A feature, both during and at the very end of the presentation. So without further ado, let me get to the first steps. What do you do when you first get a complaint? I want to note that, as you may be aware, employers, including nonprofit employers, have a duty to investigate complaints of harassment or discrimination, retaliation under U.S. employment, both state and federal laws, like, for example, Title VII. And that duty will nearly always require you to conduct some form of investigation to determine what, if any, conduct occurred that violated the law or perhaps your own internal policies. And then to take any appropriate steps to make sure that no such harassment or discrimination or misconduct or what have you happens in the future. Now, one of the areas where we see organizations get into trouble is the very beginning, when a manager first gets a complaint or becomes aware of an issue that implicates potential harassment or discrimination, and then doesn't report that situation up the chain of command to HR or to senior management or to legal counsel, what have you, as may be appropriate under your organization's rules. Maybe they've promised an employee confidentiality, or they have decided to handle the situation on their own, but for whatever reason, they don't report it up. They try to handle it themselves, and then they might make missteps along the way that might result in potential liability for the organization as a whole. And so right off the bat, one of the key takeaways is to make sure that all managers are aware of their duty to report these types of issues up the chain of command, and to be trained at a minimum, on how to recognize the types of issues that trigger an organization's duty to investigate and take appropriate action. And actually, one of the questions relatedly is, what is a complaint, right? There's sometimes this misconception that an investigation should only be conducted when a formal complaint has been launched. And that's simply not the case. A complaint can be informal, it can be oral, it doesn't have to include any magic words. You don't have to say discrimination or harassment or retaliation, right? And the duty to investigate is triggered when that complaint is brought to the attention of any manager within the organization. That there's no requirement to include it to any particular person. So that's the first step. The first step is to identify that an investigation needs to occur. The second step is to put an investigation team into place. And depending on the circumstances, the investigation team may include HR, it may include their internal management, if not implicated by the allegations. It may include your internal legal counsel or perhaps outside counsel. But the key is to make sure that the investigation is conducted by individuals who are independent, who can make a fair and unbiased assessment, and who can do so, are trained to know how to conduct the investigation. Now, the first thing that, or one of the first things that your investigation team is going to do is they're going to provide notice to involved parties. If they haven't already notified relevant parties within the organization, you're going to want to notify HR, management, legal counsel, and what have you. But then you're also going to want to respond to the complainant. You're going to want to let them know that your complaint has been received, that we're taking appropriate action. We take your complaint very seriously, and provide some important instructions up front, like notice of the company's non-retaliation policy. And then, depending on the circumstances, the investigation team may also consider providing notice to like the accused party, the alleged harasser or what have you, particularly if the allegations are of such a nature that immediate response is required. But again, that's going to vary largely depending on the investigation and the facts at issue. As far as confidentiality is concerned, we've alluded to this already, but it's important that the investigation team not promise complete confidentiality, because they have a duty to conduct a full and thorough investigation, and that by nature may require the reporting of certain details, perhaps allegations or names up the chain of command. But at the same time, it's going to be important to make sure that the investigation team does preserve confidentiality to the fullest extent possible, and doesn't disclose allegations or identities of interested parties to others, except when necessary, except on a need-to-know basis. As far as retaliation is concerned, from the very first steps all the way to the very end, it's going to be crucial for the organization to be sensitive to not take any action that might be construed as retaliation against the complainant or against anybody who cooperates in the investigation. And sometimes we see this come up when an organization is keen to take action up front to protect the complainant. Perhaps they want to move the complainant to a different position or take some other action to protect them. And depending on the circumstances, that may be appropriate. But again, you want to be very sensitive to not taking any action that is going to change the terms and conditions of that person's employment, or that could be construed as retaliation, like a demotion or something along those lines. And then the final point here, document preservation. The investigation team will want to send out a litigation hold memo to preserve any documents that are going to be relevant to the investigation, to the complaint, and related issues. And this is another area where we see organizations sometimes get into trouble, because the litigation hold memo can be complicated, can be technical. You want to make sure that it's broad enough and it includes the right language to cover the right documents. And you want to also make sure that it's distributed to the right people, to make sure that the right documents are preserved. Otherwise, a failure to do so might result in some pretty severe consequences if this matter is ever litigated and a court determines that the organization didn't fulfill its duty to preserve relevant documents. All right. So for most investigations, I think one of the first steps that the investigation team will do is identify and review any relevant policies that are implicated by the allegations. And that could be anything from your EEO policy or harassment policy, employee conduct policy, bullying, ethics, whatever the policy is, maybe even third-party policies if they're implicated. And that's going to inform the team's decision as to what conduct, if any, occurred that violated your policies, your organization's policies at the end. And it's going to shape the scope of the investigation. May impact the types of questions that you ask during your interviews later on. And then the next step will be to identify, to collect, and to review the documents and the electronically stored information that's going to be relevant to the investigation. This is going to be anything from various complaints made by the complainant and others, materials referenced by those complaints, communications by interested parties, your emails, your instant messages, text messages, voicemails, maybe even video. The electronically stored information category is broad. It could implicate lots of different types of materials. And it may also implicate third-party materials that are not owned by your organization, like contracts, policies, communications, that sort of thing. And then, in addition, at this early stage, the investigation team is going to want to identify categories of documents that they'll want to collect in the future from relevant witnesses and from other parties. I've never seen an investigation where all of the relevant materials are available up front, so you want to make a plan for that going forward, which really leads me to the next point, the need to identify appropriate witnesses to interview. And this is going to involve not only fact eyewitnesses, like somebody who actually saw or heard the harassment or discrimination or whatever the misconduct was, but also other types of witnesses that might have relevant information, which could be managers in place, co-workers of the complainant or other parties, really anybody who has pertinent information regarding the allegations. And this could be comparable employees, the last bullet. And here, the idea is to identify any employees who may be in a similar position as the complainant, anybody who was in a position to be exposed to the same misconduct or harassment or what have you. And by the way, that might also include third parties, not just comparable employees, other individuals who may have been exposed to the same type of conduct. So moving on to the next phase. Now, once all of that is done, the investigation team is finally ready to proceed to the interview phase of the investigation. And generally, I don't like rigid rules, but generally, I think it's safe to say that it's a good idea to interview the complainant first or early on in the investigation process for a number of reasons. This interview is important because it allows you to get clarity on the allegations. It allows you to identify key witnesses, key documents. Oftentimes, you can really identify the real issues, what the real concerns are, which may not be immediately clear from the complaint itself. And then it's going to shape the scope of the questions that you ask in the later interviews to the accused party and to other witnesses. Before you get into the actual substance of the allegations, you're going to want to cover some ground rules with the complainant upfront before you get into any of that. And that's going to include some instructions like a brief overview of why you're speaking with them. This is a fact-finding investigation in response to your complaint. We take this very seriously. You want to assure them that they've been heard. But then you also want to ask them to be candid and forthcoming, share any relevant information, especially if they're reluctant to share names or details of their allegations. you're going to want to instruct them not to discuss the interview and the investigation with others, that you'll preserve confidentiality to the extent possible, but again, not overpromise and promise complete confidentiality. And then you're going to want to remind them of your organization's no retaliation policy as well. Towards the end, when you wrap up, it's a good idea to let them know when the investigation is done, we will reach back out and give you an update. But again, don't overpromise, and don't promise them that you'll, for example, disclose whatever the ultimate remedial action will be, if there is any. During the interview, you're going to want to take notes to document the process. Typically, these are not like recorded, or it's not a deposition, but you do want to take notes to make sure that you document what's said. And in fact, I would recommend having a separate note taker with you in the investigation if possible, so that the interviewer can focus on the questions and the feedback and follow up as necessary, and have a separate person taking notes and focusing on that. As far as the interviews of other parties are concerned, it's going to be similar instructions up front. You're going to want to tell them not to discuss the interview with others, that you'll preserve confidentiality to the extent possible, remind them of the no retaliation policy for participating in the interview. But you're also going to want to be careful not to disclose information, confidential information, more than necessary. You're not going to want to go into the details of the allegations or the identity of the complainant or the accused party unless there's a good reason to do so. And then similarly with the accused party, similar instructions, you want to give them notice of non-retaliation policy by or against the accused party. You may also want to give them notice of whatever the policy is that's at issue, that's alleged to have been violated. And then you want to take notes, of course, during the interview. Once all of those are done, you're going to want to, as the investigation team, consider what are the next steps, follow up on any leads, any potential witnesses. Is there a need to re-interview anybody based on new information we've discovered? And then you're also going to want to consider, is there a need to take witness statements or affidavits from any of the people that you've interviewed? And that's going to largely depend on the facts, the severity of the allegations, to the extent that there are any credibility issues, or to the extent there's any disputed facts. I think it'll largely depend. All right. And in the interest of time, to make sure that we address this, we also wanted to address third-party complaints and how they're different from employee complaints. This often comes out for our nonprofit clients. It can come up in a variety of situations. Some common third parties might be clients or association members or volunteers, donors, visitors to your location, contractors or vendors, or sometimes directors of association at a trade show or at a convention or at a meeting or some other type of event like that. Really, it's anybody, any third party that your employee might come into contact with while in the workplace or at a work-related function. This comes down to two different factual scenarios. One, when you have a non-employee that's the alleged accused party, the alleged harasser, or two, when you get a complaint from a non-employee that's either against your employees or against another third party. For the first scenario, when you get an accused party that's a non-employee, it's important to note that your organization has a legal obligation to protect its own employees from harassment or discrimination by others, right? It's not enough to say that person doesn't work for us, or we can't control the behavior of that third party. You do have a duty to respond, and that may include an investigation to the extent possible, right? Alternatively, it may also be appropriate to give notice to a third party employer or third party entity for them to conduct the investigation to the extent that you can't. And then on the flip side, when you get a complaint from a non-employee, when somebody that's not your own employee alerts you to a situation, the legal obligations may be a little bit different because most employment laws in the US, at least the federal laws, apply to employees. That's a little bit different on the state level where they can be sometimes broader and apply to non-employees. But regardless, you may still want to investigate the allegations, the complaint, for a variety of reasons. One, non-employee complaint can still implicate harassment of your own employees that you would have a legal duty to respond to, or harassment by one of your employees. And sometimes a growing number of organizations have policies that are broader than what's required by the law, and they may prohibit non-employee harassment. They may cover non-employees in the policy. And so if there's a violation or potential violation, you would want to investigate that. And then, of course, finally, as a general best practice, it's a good idea to investigate this, whether required by law or not, just to foster a healthy work environment. The circumstances of the investigation will largely determine how you proceed. So whether your organization has regular contact with this third party, or whether it was like a one-time event, one-time interaction, will largely determine how you respond to the complaint. But I do want to note that it is still appropriate to take some form of action, even if it's limited contact, right? Even if it's a one-time sort of event. And again, this may be a situation where it's appropriate to provide notice to some other third entity when you're not in the best position to respond. Understandably, your access to interested parties and to relevant documents is going to be more limited and might make the investigation a little bit more difficult. But again, consider whether it's appropriate or whether it's possible to interview third parties or request documents from third parties, particularly when there is some sort of established professional relationship that would make that possible. And then finally, of course, the remedial action, ultimately, if there is any, will be different because it's gonna range anywhere from notice or a warning to a third party to perhaps limiting some interactions or perhaps providing notice to a third party entity, or might even require terminating our professional relationship with a third party. So it's going to vary widely. And I think with that, I'm going to transfer over to my colleague, Todd Horn.
Thank you, Carl. I've been asked to remind or tell everyone that the CLE code for today's presentation is Claims 2021. Okay, so now that you have finished the investigation as outlined by Carl, you need to go to the next step, the decision. And we're going to walk you through the protocols to follow in general. We're going to use a harassment claim as an example because they're usually the most complex, but the principles we talk about will apply to other types of claims you are investigating. So the first step is you have to decide, based upon the results of the investigation, is the claim substantiated or not? And you have to make a decision, yes or no. You cannot punt on this. You can't say maybe. You have to decide, and what your decision is going to pave the way for your next steps. In order to make the decision, there's some steps you want to follow. Step one is you first need to identify the decision maker. Who is going to be involved in the decision? And that is basically two groups. Number one is folks who are not making the decision, but are in advisory capacity. Usually it's HR, usually it's the person who's conducting the investigation. It may or may not be outside counsel. And the other group is the actual person or persons who will own the decision. Because if it turns into litigation in any form, you're going to have a face of the decision to provide testimony of the basis. Usually it's someone in the chain of command of the accused. It may not be the direct supervisor because there may be some conflicts of interest. They may have a personal relationship. The supervisor may really need this person and therefore doesn't want to have anything bad happen to them. So sometimes it's better to have someone higher up in the chain. Ideally, you just want one decision maker. Two, sometimes three, it gets really cumbersome down the road. And then the group gets together of the decision makers and those who are providing input, and they decide what is the standard of proof we're going to apply. How are we going to weigh the evidence in order to determine whether or not the claim is substantiated? There's many standards that are available. You can use reasonable doubt, clear and convincing. Carl and I, however, recommend what's called the preponderance of the evidence. It's the easiest to apply. It's basically 50-50. Is it more likely or not that the claim is true? And also it's important to know that if this turns into litigation, that is what that is the standard the jury is going to use. So you want to make sure that you apply their same standard to help you out and minimize the chance of a lawsuit. And in weighing this, you're going to use your own common sense that you use every day in dealing with your friends, your family, your coworkers, and everyone else you interact. So the next step is the factors to consider, and this is the meat of the analysis, and we call it DRIP in the harassment. The D is duration. How long did the harassment or harassing incidents take place? Was this a 5-second off-color joke, or was it a 2-hour berating? Was it moving someone's hair off their shoulder, or was it a hug that just lasted forever and ever and became very uncomfortable? Next R, repetition, the frequency. Was it a one-time event, or is it a pattern? Is it happened once a month for a year, or once a year for 5 years? These are factors you're going to want to weigh. Next is intensity, severity. How bad was the conduct? Are we talking about maybe a suggestive joke they heard on Saturday Night Live, or an overt, repugnant racial or ethnic or gender-based slur? Was it touching the shoulder or touching the rear end? And lastly is physical. Was it physical or verbal? In most cases, if it's a touching, it's going to be treated far more seriously than an email or even maybe a verbal statement. So once you factor all those in, you get the decision makers together, and that person decides based upon the evidence, is it substantiated or not? Then should reduce the decision to writing. That how much the writing is up to you. Some of our clients like a very long, detailed analysis. Others want just like a high-level executive summary. So there's a record of what happened in case there's litigation, they can be reminded. All the documents you will want to preserve, of course. And then if you have multiple decision makers involved, you're going to want to make sure all of them agree on the decision, and that is put in writing. And the reason that's important is Carl and I have had many cases where you have multiple decision makers, and then there's a lawsuit, and suddenly everyone's pointing at each other. I didn't want him fired. That was them. And you have this disagreement on decision makers of what the decision should be, and nothing. That is a surefire way to lose a lawsuit, or at least make it more expensive. So if you get buy-in, clear buy-in at the front end, you'll be a lot better. Carl, you advance the next slide. Okay, so here in our situation, what do you do if the claim is substantiated? You have decided that it is more likely or not that it happened. Next, you need to decide on what is the remedial action. Now, we use remedial action because that's the word the courts use, and it is broader than just what is the punishment, what is the discipline. It includes other types of things, but of course, discipline and punishment is the core piece of remedial action. Remedial action has one goal, and one goal alone: make it stop. Make sure it doesn't happen again. So whenever you are having these discussions on what to do with a substantiated claim, do not lose track of that. That is the ring you want to be running for. And the reason it's important is the EEOC and the courts take the position that if an employer is not aware of harassment, and once it learned of the harassment, it took prompt remedial action that made it stop, in many cases, there's no liability. And that's ultimately what you want to do, is protect your organization from liability. So determining the level of discipline is sometimes tricky, especially for those of you who have a zero tolerance policy. And I suspect that most of you do have a harassment policy that says something like, our organization has a zero tolerance towards all forms of harassment and discrimination, and any violations will lead to discipline up and to including. In these discussions of determining what is the appropriate discipline, don't go down the zero tolerance rabbit hole, because in the purest sense, I've been involved in discussions where folks say, well, zero tolerance means one strike, you're out. There's no second chances. And therefore, if you just tell one off-color joke, you're fired, or one suggestive email, you're gone. But if you set the bar so low that type, even maybe inappropriate behavior is punished with termination, you're going to start generating discrimination claims, as some folks are disciplined for minor transgressions and others are not. So what zero tolerance really means, and even if you don't have zero tolerance, you should apply this, is you don't ignore claims of discrimination or harassment. You respond accordingly under the circumstances as the evidence leads you, okay, if the claim is substantiated. So how do you, with all that, make a determination of what is the appropriate discipline? We recommend a very simplistic place to start. You take a 1 to 10 scale of level of severity of discipline. Say 1 is a verbal warning, 2 is a written warning, 3 is a suspension, 4 is a demotion, 5 and up is termination. It's going to really depend on your organization, but you have kind of the menu of progressive discipline. And then the second scale is the drip scale we talked about before. After you weigh all those factors, severity, repetitiveness, frequency, physical or written, you determine how bad is it on a 1 to 10 scale, okay, factoring it all in. And then where do the two overlap? So let's say your investigation revealed that this behavior was probably a 6, and under your progressive discipline policy or discipline policy, 6 is termination. That's probably the default position you want to start with. Not that you're going to be stuck with it, but that is a starting point, because if you start from the bottom and work your way up, it sometimes gets untidy. But as I said, it's just a stake in the ground. It's not necessarily the final decision. Once you're there, you ask yourself, obviously, we want to make it stop. And terminating someone would make it stop, but you want to test that against other questions, okay? How have you treated similarly situated employees who engaged in that type of behavior? Because you don't want to have a termination and find out someone of a different protected class got a pass, because then you've got a lawsuit. Was the accused, when they confronted with this, were they defiant and diversionary, or were they accepted and contrite and truly apologetic? So you have a sense it's not going to happen again. Is there prior discipline for this person? What is the impact on other employees, particularly with bad acts that are known? If you give someone a pass for truly bad behavior, it's going to perhaps encourage others to engage in similar behavior, which can create more toxicity in the workplace, which you don't want. And what about, and get this question a lot, what about the value and productivity of the accused? What if the accused is the top sales performer and is generating a lot of revenue for the nonprofit? It's not relevant, okay? And not relevant at all, either towards your liability or the application of your harassment policy. It doesn't go into the equation. So after you have decided on the level of discipline, you need to kind of close out the case with the parties through notice. To the accused, it's pretty standard. If they're terminated, they're gone. If it's something else, they will get it. You will document the process and it will go in their file. You're also going to, if the person is not terminated and they're going to still be there, you need to admonish them that there is no retaliation against either the witnesses who participate in the investigation or the complainant. And if you do engage in retaliation, you will be fired. The communication to the complainant, if it's substantiated, is not as straightforward as it seems and depends on the circumstances. If the decision is termination, it will be obvious, the person will be gone. But if it's not termination, in many cases, that person is not going to, the complainant is not going to be satisfied. And the last thing you want to do is engage in a debate. As you are the organization, you make the decision, not them. So generally speaking, the less said is the better approach. You certainly want to thank them for bringing the complaint to your attention because that's what your policy encourages. You remind them that there is no retaliation against them. And if they do get a whiff of retaliation, they come to you and report it. Okay, next slide, Carl, please. So if the claim is not substantiated, it's a little bit easier. The notice to the accused is, you're not being punished, but you want to remind them no retaliation against the person who complained. They have the right to do that. I meant usually said, and the witnesses. I don't think the witnesses either, whether substantiated or not, you really want to engage with. Maybe thank them, but nothing beyond that. So the tricky part is if you have a complainant who you're basically saying, we don't believe you. I mean, that's what they're going to hear. You want to be delicate. You want to make sure you appreciate that they brought it to your attention because that's how your system works. Remind them that there is no retaliation. And then this last set of bullets, root cause analysis. This actually applies to whether or not the claim is substantiated or not. You want to reflect back when this is over and figure out what caused this problem in the first place. Now, we've been focusing here on a hypothetical harassment type decision, but it applies equally for other types of discrimination claims you may get, like a promotion denial or a compensation dispute, or maybe even a poor evaluation that is claimed to be on discriminatory basis. Take the opportunity to make sure there's not some sort of slippage in your HR processes that is causing this to happen. It could be as simple as a policy review. It could be training protocols. It could be revamping your promotion process, for example, to make sure that it is gets rid of the problems that were causing it in the first place. Okay, Carl, we jump to the next slide. All right, some problem areas. These are issues that Carl and I have seen, unfortunately, many, many times, and these are not easy questions to answer. But we're going to go through. These are the four that we see the most. First one is request for confidentiality. So let's say you have an employee who comes to the HR office and says, oh yeah, by the way, at the holiday party, John Doe drank a little bit too much and on the way out, pinned me against the elevator wall and kissed me. But I know that John has a very jealous spouse and they have a bunch of kids. And if the spouse found out about it, she would divorce him in a second. And I don't want that on my conscience. So I don't want you to do anything about it. And then they walk away. So they're basically begging you not to do anything, but they've dumped this live grenade on your lap. What do? Well, you cannot, in that circumstance, treat this as confidential. You cannot ignore it. You have to do something. You have to go through an investigation. It's not necessarily that you have to go through all the steps that Carl said, although you might have to. But the reason is you have to assume that this is not a one-time occurrence. It could happen again, and you now have notice of it. So let's say 6 months later, John Doe groped someone else, okay? And that person complains and does not want confidentiality. And it turns out you knew, they find out you knew. They're not gonna feel sorry for the first person. They're not going to feel sorry about the potential marital problems. They're going to feel that they were violated. And you, as an employer, are going to potentially be on the hook for that harassment because you knew there was a propensity to it, and you did not, back when the first complaint hit your door, take prompt remedial action. So don't respect requests for confidentiality of harassing discriminatory behavior. There's no upside to it. Number two are stale complaints. Now, we are, all the different organizations are in different phases of coming back to the office. Some are still remote, some are hybrid, some are all in. But we're finding some common thread is that once folks get back into the office, they bring up things that have happened before. Some of them maybe even pre-pandemic, or things that happened during Zoom calls or whatever, but they're not current. They're not in the last week or month or maybe even 6 months. So, and some of them may be, over a year old. And the temptation is to think, well, you didn't complain about it then, so how bad could it be? And you ignore it. Not a good process, not a good strategy. Don't ignore it. You want to treat an older complaint with seriousness. Now, obviously, if it's 4 or 5 years old, your ability to investigate is going to be different. You're not really going to have current liability, probably, due to statute of limitations. But you are going to want to look into it because, again, if this person who was alleged to have engaged in bad behavior 2 years ago is still in your organization, you're going to want to make sure that it is addressed with him. And it may be that's the first step is you confront that person and talk about it, and then calibrate your investigation as you go forward. Next one is illegal behavior. Do you call law enforcement? So let's use an extreme situation. And I know you all are largely white collar type organizations, but we do on occasion see some pretty egregious behavior in all types of workplaces. So let's say back to the situation where the person at the party pinned the coworker against the wall, kissed her against her will, and groped her, a sexual assault. And you believe that it happened. Do you call the police? Your instinct may be yes, but our advice would be no, don't do it. That is the responsibility of the person who was the subject of the attack to do, not you. And the rationale is all the states in which you do business have laws called malicious prosecution. And what that means is if you start the ball rolling on a criminal complaint against someone and it gets dismissed down the road, you are potentially on the hook for bringing that. And there can be civil liability and damages attached to it. And you can't control what happens down the road. So, again, the temptation is going to be that the person is punished and answers for their misdeeds, but let the victim do it. And lastly, before we turn to some of the Q&A, reference requests. So let me give you a quick hypothetical. You have a woman comes in and says, male John Doe groped me over and over again, and I don't know what to do, so I'm reporting it. You call John Doe in and say, John, you've been accused of groping this coworker, kissing her against her will. And he says, well, I didn't do it, but I'm sure if you investigate, you're going to find I did something wrong, so I'm quitting. And he quits. A month later, your phone rings and you get a call for a reference for this John Doe. And let's say it's like a daycare center, okay, where the person, if a predator, could be in in a horrible situation. Do you tell that reference that John Doe was fired or quit because he was under investigation for groping someone. And again, I can just hear you through the computer. You're of course saying, yes, of course we're going to. You know, your moral compass just points in that direction. But again, where advice is no, you don't. You stick to what we hope is your policy of providing just a neutral reference, name, rank, and serial number. In other words, confirm employment dates, confirm position, maybe confirm salary. And the reason is, if you are to spill the beans on this and it turns out it's not true, you can get sued by John for defamation. And especially if the person doesn't, if the place doesn't hire him based on that, you know, the damages can add up and it can include lost pay. So you're going to be tempted to want to, confirm this information, but don't. Just provide the bare bones information. And if you really, really feel you need to, sometimes an employer or, the former employer will say, well, we will give a full we will give full details, but you need to sign, this person needs to sign a release absolving us from liability, no matter what we say. In many cases, the new employer kind of understands what's going there and proceeds cautiously. So Carl, I'm going to, I think, spend the rest of the time trying to field some questions that have come in. Do you want to take the first one?
Absolutely. We've got some great questions that have come in. All right, the very first one that I got is, you mentioned an investigation team. Can it just be the HR manager? And the answer is yes, absolutely. That doesn't necessarily require a full investigation team. Who investigates these sorts of complaints will be largely dependent on the facts and the circumstances. If you have a small organization and a fairly straightforward complaint, it may be appropriate for the internal HR manager to investigate. I will say that it is helpful to have some help occasionally during these investigations. I mentioned the interviews. I like to prefer to do it with two people, but there's no set requirement that you need to do that with a particular team. There may be circumstances where things get a little overcomplicated. It may be a good idea to bring in others. But Todd, did you have ideas on this?
No, I think that's good. The next question is, for reference requests, does this need to be a blanket policy not to provide any details, even for great employees? Can this be the policy of the HR department and staff, provided references as needed? We recommend a neutral reference policy in all situations, even for great employees. And the reason is, if you have a great employee who leaves and you provide them with a great reference, and then you have another employee leave and you give them a neutral reference, and that other employee is a different gender or ethnicity or protected group, they're going to say this is discrimination, because the discrimination laws actually apply even after employment. So no good deed will go unpunished in the reference world. So the real towing the line in providing only neutral references in all cases is, I put it as a top 10 best practice that's not to be broken at all.
I got another really good question. When we see this come up all the time, it's what happens if at the end of the investigation, you really just get into a he said, she said, and you really don't have enough to say that it did or didn't happen. Going back to Todd's point of, is it substantiated or not? Well, you still need to decide if it's substantiated or not. But if you've done a full investigation, you've truly done everything you can't go ahead and discipline somebody for something that you don't have sufficient evidence to determine that something had happened. There may be other things that you can do. You can maybe implement some training, and you can take some other steps to address this on a policy level. But in terms of discipline, remedial action, you can't discipline somebody for something that you can't determine happened. Todd?
Yeah, and just coattailing on that happens more often than not, because there are not going to be videotape records and smoking guns. You're going to have a situation where someone's lying, and they're both they both seem to be telling the truth, but as Carl said, you got to unravel it. What if an employee or witness wants to have their lawyer present during the interview? And this is usually the person who is being accused of the misdeeds that wants to have the lawyer present, is generally not the complainant or a witness. But our pretty strong advice here is don't allow it. Not that lawyers aren't great people, but having a lawyer involved in the investigation creates an adversarial tone that shouldn't be there. They don't have a right to be there. And I've never heard of a situation where our client says, we're really glad we let the lawyer in. It's usually the opposite, that it turned out to be a complete nightmare, because they're not looking after the interest of the organization, they're looking after the interest of their client, the accused. So what we advise is to tell if it's the accused, no, your lawyer cannot be present. And if they say, well, I'm not going to cooperate, you can say, that's fine. We will make our decision without your input. And that almost tips your hand of where it's going. But that's what we say. And one thing to note that is if you have your counsel, either in-house counsel or outside counsel, conducting the interviews, and one of the persons has a lawyer representing them, but your counsel cannot communicate with that person. Okay, there are ethical rules that prohibit it. So you would need to have someone who is a non-lawyer, either in HR or management, conduct the investigation. Carl?
Who in an organization should or should not have access to harassment complaint records, or generally looking at specific employee records, and on what occasions should they have that access? So I mean, this is going to largely depend on what the investigation is, who's part of the team, but it should be based on a need-to-know basis. If that manager or that director doesn't have a business reason to have access to that, then there's no reason to disclose that. HR should be, or whatever the internal processes, should be the gatekeeper of all of that information. And there's no reason to disseminate it to managers not involved in the decisions or the investigation or so. No reason to do that. There may be other special circumstances that might come up, but that's as a general rule. Todd?
Yes. This question I think maybe answers two, but it reads, who in the organization should or should not have access to harassment complaint records? And when, generally, on what occasion should they have that access, in particular officers, directors? It's going to depend on the organization, and it's oftentimes dependent upon the size of the organization and the function of the person. So the question is, why do they need to see it? Okay, is there a legitimate basis to have X position have access? Even with some organizations, HR, the benefits side may not need access to complaint records, whereas the employee relations side does. Okay. So in other words, there's not a one size fits all answer. If they can articulate, or you can articulate, a business related reason, either litigation avoidance or HR compliance, that a person should have access, then they probably should. It's usually reserved for higher level folks. You don't want to open this to the rank and file. Definitely not outside HR, because you want to, treat these records confidentially. And when you do provide this information, sometimes you can say, okay, we'll let you read it, but we're not going to give you copies of it. Or you could, of course, remind them of the need to protect this information. But certainly, if someone is in the decision chain, or who's going to have a say in evaluating discipline or remedial action, it makes sense to have them have access to it. Otherwise, officers and directors, maybe a high-level reporting would be sufficient, as opposed to having full access. Carl?
Yeah, we've got, if an organization interacts with non-employees, from directors to volunteers to third-party business people, for whom there's no employee file, so there's no personnel file for that third party. How does the organization keep track of that? So you still want to document it. It may be as simple as opening a separate like HR file that's kept separately from personnel files, but you want to have some form of record. As long as you keep it, and as long as you keep it separate from regular employee files, I don't think there's any set rule for how it should be kept, unless there's medical information or something in there that you want to make sure you preserve confidentiality.
With regard to investigations, what about recording the interviews? Should we record the interviews or allow the employee to record? Our preference is no. You don't want to have recordings of these. You all will have someone involved, either the person taking the interview or maybe a team taking notes of what is said. You have to assume that this could turn into litigation. And if it turns into litigation, there are rules of evidence that are going to guide what comes in and comes out. And the judge makes that decision. And if you have just a freewheeling recording, it almost becomes a business record that comes in automatically. And I guarantee there's going to be stuff in there you don't want. And in a normal world, the court would say it doesn't come in. And so our strong recommendation is don't record it and don't allow them to record it. Now, it doesn't deal with the problem of secret recordings, and that does happen. I mean, everyone now has a smartphone with a recording feature that they can put on the pocket and record without permission, and it does happen. Most of the states in which most of you are organized don't permit that, but some states do. So there's nothing wrong with, if you think that it's being recorded, is tell them that this is not, you're not permitted to record this, and leave it at that.
I have a simple one. Do you suggest that affidavits are signed? So this is in reference to getting affidavits from witnesses that have been interviewed. I think if you're going that step to document an actual interview, you probably would want to get it signed. You want to include a special language at the bottom that legal counsel would include there, saying that this is signed under a penalty of perjury in reference to the appropriate section. I think if you're getting an affidavit, you want to make sure you can use that affidavit later in potential litigation if needed.
It looks like we may have time for two more. On the reference issue, what about a yes, no, eligible for rehire? Does it make a difference if an investigation substantiates the claim? I don't like eligible for rehire or not because it's loaded. And in many states, in the Mid-Atlantic region, a defamation claim is a very low bar. It's very easy. If you tell a prospective employer of a former employee that the person was incompetent, and use the word incompetent, that is, according to the courts, defamation on its face, that they are incompetent. And that can get you in trouble. And of course, incompetence is in the eye of the beholder. And if you say they're not eligible for rehire, it creates the inference in some that they're not competent. So it's a backdoor way of potentially getting you a defamation claim. You could probably win it the end of the road, but why even worry about getting sued or not? Again, with former employees, it's not, you don't have an interest. You don't have a dog in that fight. So just keep it neutral. Carl, do you want to take the last one?
Let's see here. What about requests to make employees available for third-party investigation? So if someone's asking to interview one of your own employees, this is a little tricky. I'd be hesitant to do this. Todd, have you had this situation come up before?
Yeah, I have, and I think it depends on the person. So if you have my gut feeling is no, we will deal with our own problems. So if one of your employees is accused of misbehavior towards a third party, give us the information. We will do the investigation with respect to them. But I can also see in some situations the two businesses have a very close relationship, a good partnership, and you don't want it to be derailed because of something like this. So I think there are some cases where you would let it happen, but assist on written responses, questions. That may be a way to deal with it aside from having to tell a partner business, putting your stiff arming them and saying, we're not going to cooperate.
Thank you, everybody. I think that's all the time we have.